Welcome to our series on COVID-19 and the American government. I am Dr. Rodel Aguas. Our topic for today is protests and the pandemic. We shall study the four-part analysis of a statute's constitutionality in relation to issues on freedom of speech and freedom of assembly. Protests against the stay-at-home orders in various states mounted as President Trump issued the national guidelines to reopen the economy. These protests also mounted after he retreated from his claim of total authority over the state governors with regards to lockdowns or stay-at-home orders in the respective states. Later on, he retreated from his claim of total authority and announced that it is up to the state governors when to end state lockdowns and start reopening their state economies. However, in his Twitter account, he called to liberate numerous states from state lockdowns. This earned him criticisms by various sectors for encouraging protests on the very national social distancing guidelines that he himself asked the states to implement. He was also criticized for encouraging these protests, which appear to be more of campaign rallies for his re-election bid for presidency in November 2020. Although President Trump's supporters claim that their First Amendment rights to freedom of speech and assembly were violated, majority of Americans see this as uncalled for in a time of public health crisis, a time of coronavirus outbreak. Protesters did not only observe social distancing guidelines and were also not wearing face masks to avoid getting infected or infecting others with COVID-19. Mass gatherings like protests and public events like sports events pose several public health issues, especially during a pandemic such as COVID-19 outbreak, which has infected millions and killed thousands and still continue to infect and kill. Can the federal government or state governments issue laws or statutes to limit or restrict these ongoing protests against lockdowns to protect public health and safety? Yes. While we claim the right to exercise freedom of speech and freedom of assembly, the government, federal or state, can impose limits or restrictions on the occasion, location, and manner of expression of these rights. But laws governing mass gatherings must not unconstitutionally interfere with the right to free speech or expression and the right to free assembly. How do we determine if a law or statute violates one's freedom of speech and freedom of assembly under the First Amendment? The Supreme Court developed a four-part analysis to evaluate the constitutionality of limits or restrictions on the occasion, location, and type of freedom of speech or expression and freedom of assembly in a particular circumstance. These limitations or restrictions are also known as time, place, and manner restrictions, or TPM. The four-part analysis consists of the following criteria. Number 1, the restriction must be content neutral. Number 2, the restriction must be narrowly tailored. Number 3, the restriction must serve a government interest. And number 4, the restriction must leave open alternative channels of communication. First, the restriction must be content neutral. It must be a content neutral restriction not a content-based restriction. What does content-neutral restriction or law mean? We can understand this criterion better when we differentiate it with content-based laws. A content-based law regulates the substance or content of the speech or what it communicates. On the other hand, a content-neutral law regulates the form of the speech, such as when, that is the time, where, that is the place or location, and how, that is the manner of the speech. It doesn't care about what is communicated. Therefore, to be content neutral, the law restriction or statute must be concerned not on the message, but on when, where, and how the message is being communicated or expressed. For example, the law is not content neutral if it restricts any speech from saying anything against or in favor of state lockdowns in a pandemic. If it does, then it is a content-based law, not a content-neutral law. Next, the law must be narrowly tailored. This means that laws must be written precisely to place as few restrictions as possible on First Amendment freedoms. This is linked to the overbreadth doctrine, which is used by the courts to determine if a law or statute is narrowly tailored. For a law to be considered not narrowly tailored, it must be overbreadth or overbroad, meaning it must not be too general or insufficiently specific, making it difficult for one to distinguish what is really prohibited from what is not prohibited. In the landmark case of Gooding versus Wilson, 1972, Johnny Wilson was convicted by a court in state of Georgia for violating this state law during a protest which read, "Any person who shall, without provocation, use to or of another, and in his presence, opprobrious words or abusive language, tending to cause a breach of peace, shall be guilty of misdemeanor." Wilson complained that the Georgia statute prohibiting the use of opprobrious words or language of scorn or criticism or abusive language tending to cause a breach of peace violated the First Amendment as applied to the states by the 14th Amendment. When the case was elevated to the Supreme Court, it was held that the Georgia statute in question was indeed unconstitutional. The court reasoned that the statute was not narrowly tailored. It was vague and overbroad. It is difficult to distinguish in the statute what was legitimate from what was illegitimate speech. In fact, Georgia does not provide the specific tools to determine what are the opprobrious words or abusive language that produces a breach of peace. Next, the restriction must serve a compelling government interest. This means that a law, statute, or restriction addresses a matter of significant public concern, like an epidemic outbreak that threatens public health and safety, which is crucial in achieving a goal of the government. However, if the government or the state may have a compelling, significant, or legitimate interest in public health, public safety, or an array of other issues, they should not intrude or make impossible the free exercise of important constitutional rights like freedom of speech and freedom of assembly. Finally, the restriction must leave open alternative channels of communication. This means that there are other possible legal ways that the government allows its citizens to freely exercise their constitutional rights. In the landmark case of the United States versus O'Brien, 1968, David O'Brien burned his draft card sent to him by the government which drafted him to join the army to fight in the Vietnam War. He did this symbolic protest against the Vietnam War on the steps of the South Boston courthouse. He was arrested and convicted under the Selective Service Act for violating the federal law that made the destruction or mutilation of draft cards a crime. O'Brien complained that the law was unconstitutional and that it violated his First Amendment right to freedom of speech. When the case was elevated to the Supreme Court, it upheld the conviction of O'Brien, ruling that the federal law was constitutional. Using the four-part analysis of a content-neutral restriction, it found out that the federal law in question was a valid time, place, and manner restriction on speech. It also found that the federal law supported a legitimate government interest, which was to ensure a system established by Congress to raise an army. In addition, the court determined that the federal law did not prevent the use of numerous alternative means for O'Brien or anyone to communicate their opposition to the Vietnam War. In other words, the government did not prohibit protesting against the Vietnam War, but prohibited a method or manner of protest that disrupts the system of raising an army, such as burning draft card, which calls a citizen to join the army. We now ask, should states enact laws that will regulate protests during a deadly pandemic like the coronavirus outbreak? These laws, when challenged in the courts, will be subjected to the four-part analysis in order to determine their constitutionality, that is, to determine whether they violate the First Amendment freedoms, particularly freedom of speech and assembly. Is the law content neutral? Does it regulate the time, place, and manner of the protest, speech, and assembly? The courts will also ask, is the law narrowly tailored? Does it make it easy to determine what is prohibited from what is not prohibited? Another thing, the courts will also ask, is the law supportive of a significant government or state interest? Does it seek to accomplish a legitimate goal of the government to promote public welfare and safety? And finally, the court will also ask, is there an alternative open channel of communication? Does it allow other means of expressing our freedoms? While we respect and acknowledge the right of every American to protest, to reopen the economy, we also respect and acknowledge the right of every American to stand up against protests that pose a threat to public health and safety. Be safe. God bless. Till we meet again.